A battle for privacy in a world where information is given at the click of a button. A famous footballer tries to gag the press, but reckons without the power of the internet. So, are super-injunctions dead in the water? And how can the law control the social media? This is Inside Story. Hello there, welcome to the programme. I'm Shuli Ghosh. So, Britain was waking up to gleeful newspaper headlines on Tuesday after the already farcical saga of the celebrity privacy battle took another twist. The married Manchester United footballer Ryan Giggs had tried to gag the media after allegedly having an affair. But on Monday, he was named by a British MP in Parliament. It brought to a head the row over so-called super-injunctions granted to the rich and famous. Revealed Britain's best-known secret, says one paper. Naming Private Ryan, says another. But as politician John Hemming said in the House of Commons, Giggs's privacy had already been blown by the new media.
Mr. John Hemming.
Mr. Speaker, with about 75,000 people having named Ryan Giggs on Twitter, it's obviously impracticable to imprison them all. And with reports that Giles Coren also faces imprisonment.
Order. Let me just say to the honourable gentleman, I know that he's already done it, but occasions such as this, order, are occasions for raising the issues of principle involved, not seeking to flout for whatever purpose. If the honourable gentleman wants to finish his question in an orderly way, he can do so. Mr. John Hemming.
The question is what the government's view is on the enforceability of a law that clearly does not have public consent.
Well, as John Hemming mentioned there, thousands of people already knew Ryan Giggs' name because the super-injunction had been well and truly breached on the social media networking site Twitter. More than 2 weeks ago, an anonymous Twitter user posted details of celebrity injunctions in defiance of the law, but apparently beyond its reach. The information, not all of it accurate, was spread quickly online by thousands of users, further frustrating traditional media who could only report developments without naming names. 2 professional footballers have now sought court orders against the US-based site. It's by no means clear whether they'll succeed.
This is breaking new ground legally. The fact that Twitter is involved is a very new development. Is it likely to succeed? Well, the courts have indicated that they are going to fight this. Senior judges have said court orders have to be complied with, and the fact that there may be some comment out there can be disregarded. The principle of the rule of law must remain.
Well, let's discuss the ins and outs of this with my 3 guests today. In London, Martin Bentham, the Home Affairs editor of the newspaper The Evening Standard. In Cambridge, Stephen Murdoch, a researcher in the security group of the University of Cambridge. Also in London, Carl Gardner, a former UK government lawyer and editor of legal news website headoflegal.com. Welcome to the programme, gentlemen. Martin, let me start with you. Was there a little frisson of victory when the Evening Standard was able to go to press on this properly and name Ryan Giggs?
I'm not sure there's a frisson of victory. There was certainly a great feeling that the thing had reached a denouement where some resolution had been achieved. Clearly it was becoming very difficult for all the newspaper industry, I think, and indeed the broadcast industry when the name was out there. Nobody could report it in the mainstream media, and that did generate a sense of unfairness. Whether what happened was the right thing is a different issue altogether, I think, but certainly what has happened with the spreading of the name on Twitter and the ban on mainstream publications revealing that name was becoming untenable in many ways. Yeah,
I mean, is there a general feeling in your industry that super-injunctions unfairly impact on your business when it just seems to be a free-for-all on the social networking sites?
I think that's true. I mean, the answer to that might be a free-for-all everywhere, although many people would think that there are legitimate areas which perhaps should be restricted. In fact, the Ryan Giggs case, I do feel uncomfortable myself a little bit with this case because it's probably one of the worst examples, given that the judgment that was given by Mr Justice Eadie last week made the point that there is a potential allegation of blackmail involved here. Now, blackmail has always been something which has been case has been kept confidential because the very publication of the details of such a case would hand victory to the blackmailer clearly by getting the information out there. So this is probably one of the worst examples for press freedom because of that fact. Having said that, clearly, again, it is just not satisfactory that there is a completely uneven playing field, that information is widely available to lots and lots of people, but not available to the readers of newspapers such as mine and indeed any other broadcast or newspaper in England and Wales, not even in Scotland, in fact, never mind the rest of the world.
Yeah, Carl, I mean, this whole issue about super-injunctions, first of all, they have been derided as a privacy law that's open only to the very rich. What do you say to that?
Well, the first thing I'd say, Shuli, is in the case we're talking about yesterday, we're not talking about a super-injunction at all. And I think one of the confusing elements about this whole debate has been the use of that term, which really just means injunctions, the existence of which you're not allowed to report or disclose. The use of that term to cover any kind of privacy injunction or anonymised injunction. I think we have a hopelessly confused debate for one thing.
But this injunction was taken out. I mean, it was a gagging order on the media to prevent the media discussing details of an alleged adulterous affair.
Yeah, well, I'm not quite sure what the allegations were. But so it was. But we have privacy law. Parliament enacted it in the Human Rights Act, knowing what they were doing. I understand Martin's concern about the uneven playing field, and I think we have genuinely have a problem of enforcement of the law with Twitter, I think, and the rest of the internet, by the way. I think we might be slowly working ourselves towards solutions to that, but I don't think the answer is simply a free-for-all. We have to have the rule of law. Incidentally, as far as I know, this order is still in force, which is why I don't want to name it.
It is in force, and the only reason we can talk about it, of course, is because an MP used his parliamentary privilege, and we can quote him. Do you think the MP did the right thing?
I certainly don't. I think John Hemming abused parliamentary privilege yesterday. I don't think there's any great public interest in this story. I've yet to hear what it is. As Martin said, I think this is a bad case for the press. If I were representing a newspaper, I would be a bit ashamed of this victory, actually, that I think it's a bit of a Pyrrhic one. I think the media are great, and it's a heroic profession. I wish they would take themselves seriously and do the investigative in journalism about genuine scandals and move away from this tittle-tattle, frankly.
Stephen, let me bring you in here because, first of all, there is a serious question about what constitutes the public interest and the public's right to know. But secondly, I mean, can you ever protect that given the way that social media works today?
Well, the internet is sometimes described as being borderless, but it's not really. These companies are all based in the country and they're all obliged to obey that country's law. In this case, the Twitter is based in the US, and we run into the problem because US privacy law is very different from that in the UK. And so while you can enforce judgments internationally, there's quite a lot of pressure in the US not to enforce British libel laws because that fundamentally doesn't agree with the beliefs of the US.
Well, in fact, Twitter has said, well, go ahead and try and sue us, bring it on, because, you know, we are a US company. So Twitter certainly doesn't think that any court cases against it are going to succeed. Yes, and Twitter have a record of trying to challenge court orders that threaten their users. They've done that over WikiLeaks, for example, very recently. And various people in the US have discussed specifically the UK libel laws and saying that this is not appropriate for the US and therefore they should not be enforceable, even if they were enforceable in the first place. OK, let's just have a look at what happens when Twitter gets it wrong, because the information on Twitter isn't vetted, of course, and when users post erroneous information, they can seriously damage a person's reputation. Jemima Khan was one such victim. The socialite was named on Twitter as one of several celebrities who'd taken out a super-injunction over an alleged affair. Now, she vehemently denied this. And she later said, I hope the people who made this story up realise that my sons will be bullied at school because of it. Plus, I'm getting vile hate tweets. Carl, it is worrying, isn't it, that people can post almost anything they want to on these internet sites, and there isn't that sort of editorial context or control that you'd get in traditional media?
I suppose not. And of course, the whole point about privacy is we're not necessarily talking about the problem of untruths. We may be talking about things that are true but damaging. You know, things about people's sex lives, things about children's upbringing, things about people's behaviour of all kinds. Yes, Twitter and the internet generally do introduce a new element to this. That can't be denied, and a real enforcement problem for authorities over the world, all over the world, and for all of us. This is not just about authorities, actually. This is about all of our rights. And when you think about it from that point of view, you're talking about perhaps intellectual property rights, commercial secrets, the welfare of children. How do we guarantee, for instance, the anonymity of rape victims, which concerns a lot of people? So this is not just about the big brother state trying to control the David of Twitter. It's also about individual people and their rights, and how companies like Twitter will respect them in an international new media environment.
Well, what's your response to that, Richard? Because, sorry, Martin, because I mean, this is one area where traditional media are very controlled by legal considerations. So making that kind of mistake is very serious for you.
Indeed. Indeed. I mean, actually, funnily enough, the Lord Chief Justice, when the judiciary unveiled a report on this whole issue last week, made the point that one of the reasons that injunctions should continue to apply to us, whether it be super-injunctions or anonymised injunctions, which are the bulk of these cases, these gagging orders, that was because we were far more reputable and trusted than the social media. And so, clearly, that is something that is absolutely true. We have lawyers working on all the stories that we put forward, as you will as broadcasters, in fact. And clearly, we are very careful not to transgress the law. Occasionally it happens and defamation cases result, but that's not deliberate, far from it. What I would say, incidentally, is that when false allegations are put out on Twitter, the law already allows the victims of that to sue for defamation. And indeed, if I were a Twitter user putting stuff out of that sort, I would be very careful about what I was putting out there, because you can be sued for defamation, and that's a very serious danger. Those who are making allegations about Jemima Khan could be in substantial financial liability if they are tracked down and sued, because they have no defence.
Do you accept that there sometimes
is in that area in that sense?
There sometimes is a public hounding of celebrities simply because they are celebrities, and this insatiable desire to know about their private lives. Why aren't they entitled to privacy like you or I?
Well, I think there is an interesting question there. Clearly, it depends to an extent how far you're going there. If it was the Fred Goodwin case, for example, which was also raised under parliamentary privilege last week, his alleged affair may or may not have some bearing on his conduct whilst he was in charge of the Royal Bank of Scotland, which obviously is a matter of great public concern.
Well, I can
in this
see
country,
the public interest in that case,
but
I mean, with
yes.
Ryan Giggs, unfortunately, the big loser in all of this is Ryan Giggs.
No, I agree. I mean, actually, as I said at the start, I'm not sure this is a great example for the media to be testing the law on this. Obviously, there is an absolutist principle which says, which some people hold to, which says that anything that is true should be free to be published. I'm not sure that's the case. In fact, clearly it shouldn't be the case because, again, where blackmail is involved, for example, the allegation that somebody's been blackmailed over might be correct, but you would restrict publication of such and the courts would seek to restrict it, quite rightly, I think, to stop the blackmailer winning. I don't think there's an absolute line. The problem that we have at the moment is that the law, again, the Lord Chief Justice made very clear, since the Human Rights Act, the law has been defined very, very, well, not very widely, but it's an abstract principle which has allowed case law. The judges are not to blame for this. The judges were handed this task. The case law, as is now emerging, has resulted in more and more of these injunctions, as again the judges themselves admitted, and the result of that is that a privacy law has been created, extended and so on, without really a debate in Parliament.
OK, well, British Prime Minister David Cameron certainly wants to set up a committee to examine the current privacy laws. He told a UK TV show that legislation had to catch up with today's world.
It's not fair on the newspapers if all the social media can report this and the newspapers can't. And so the law and the practice has got to catch up with how people consume media today.
Stephen, how does the government address this issue? Can the government address this issue?
Well, I think all these companies have to obey the law of the country they're based in. And if there is international consensus as to what rights of privacy people should have, then these can be implemented. It will take a lot of effort. Any sort of international agreements do take a lot of time to agree, but we can see successes in this area. For example, images of child abuse are very quickly removed from the internet, even when they're reported from one country being accessible from another country, because there is very good consensus internationally enshrined in law that these images are unacceptable and should be removed. I think if we want to enforce international law, things don't have to just be done in the UK, but there has to also be agreement with other countries, and particularly the US, because they host so much of the internet infrastructure.
Well, I mean, the problem with the Twitter case, as I understand it, is that some of the accounts have been set up anonymously, and the issue is trying to force the US-based company to reveal who set up those accounts.
Well, there can be several approaches taken to trying to remove this information from the internet. One is to threaten people and say that if you post this information on the internet, then we will find out who you are and punish you. For example, the defamation lawsuits potential mentioned before. But there are also technical measures which can be taken by the company without having to unmask the people posting these messages on Twitter. It could be that certain keywords could be blocked by the website, and therefore anyone trying to post these would be unable to do so.
Well, hang on. I mean, doesn't that come under censorship?
A lot of problems.
Surely there's also an issue of freedom of expression here.
Yes, this is definitely censorship, and this is what is done in many countries, trying to repress ideas which would be considered elsewhere considered encouraged, not only just acceptable. So I think before anything like this could ever be done, there would have to be transparency and consensus that what is being blocked or what is being restricted is appropriate.
Well, I was going to say, I think a lot of people would take issue at putting such wholesale controls over something which amounts to having an adulterous affair.
Yes, and I think here there is a significant difference between the US practices and the UK. In the UK, many, perhaps most of the injunctions taken out are by celebrities trying to protect their private life, whereas in the US, celebrities have much less protection of their private life. And so I don't think in the case of Twitter, they'd be willing to impose UK restrictions on their own users.
Carl, Martin was talking about a year-long review of gagging orders, which was published a few days ago. Judges have admitted that it probably wouldn't apply to bloggers and tweeters and the like. So, can we ever really see proper controls on that side of the social network?
Maybe. I mean, I think we just don't know yet, Shuli. I think we have to see this is developing. I don't think that it's a great idea for what you might call the mainstream media, I speak as a blogger and tweeter myself, to adopt the view that, you know, if Twitter or people on Twitter are getting away with it, then it should be a free-for-all. I think the answer is for journalists and the mainstream media actually to take a higher ground here. I mean, the editor's code, the code drawn up by the press themselves, says that privacy should be respected. Guess what wording they've drawn on to define privacy? The wording in the European Convention on Human Rights, which is in the Human Rights Act.
But the European Convention also, in Article 10, talks about balancing privacy with freedom of expression.
Yes, balancing, exactly. So it's not that we can say free expression always trumps privacy. Now, once you accept there is a balance here and that privacy itself has a value, not simply untruth, once you accept there's a balance here, then there must be some legal restriction on what people can say, invade in others' lives. And this is not just about footballers and affairs. This is about what you and I and everyone does in their private lives every day. If the rule of law and our rights are not respected, it's so much more dangerous.
But herein lies the irony.
us.
Do you not think that these injunctions are being granted far too quickly and for far too long? I mean, if Ryan Giggs hadn't taken out an injunction in the first place, this might never have gained the momentum that it has.
Well, I mean, the press would have published the stories. No, I don't think they're being granted too readily. The Human Rights Act contains a structured approach to injunctions, which Parliament laid down in
but this isn't about human
detail.
rights. This is about who's got the money to go to the High Court and take out one of these injunctions.
Well, that's another point. I would argue this should be much easier and more accessible to everybody. If editors respected their own code, then it would be free. There would be no need to go to court at all.
Well, I mean, you've got a ridiculous situation here. I mean, obviously I can't name any of these people, but the kind of super injunctions in place at the moment, an actor given a gagging order to try and prevent the public discovering he cheated on his wife with a prostitute, an internationally renowned chef has got a gagging order preventing the publication of a legal wrangle with former employees. One public figure has got a super injunction so tight nothing at all can be published, not even what his job is. I mean, Martin, it just seems to be ridiculous, doesn't it?
Well, I think actually just going back to the point that was made before, I mean, I think even last week the judiciary themselves admitted that there have been too many of these injunctions granted in the past. They said that explicitly. They are not the sort of feral beasts of the red top tabloid press. They are sensible, respectable people who made that conclusion. So I think it is clear that the balance has in the past been struck wrongly. They have promised to try to strike a better balance in future. We'll have to wait and see whether that's the case. Certainly, I think it does need to be defined much more closely because in some of these cases, they probably are just tittle-tattle, salacious, very enjoyable to read, possibly, if you like reading that sort of thing, if you know about it. But some of them may have some more, some deeper resonance. I mean, there's one of the cases which is also subject to an injunction in which the person who's conducted an affair, an actor, I think, was having an affair with a colleague. That colleague has subsequently been dismissed. And clearly there's an employment issue there potentially. So the Fred Goodwin one again is another example, as I cited earlier. Sometimes what appears to be just a person's private life may have something which lies beyond that. Now that's not always clear, and you can't always prove that before it's been talked about.
What's your response to that, Carl?
Well, it may have. We don't know. We don't know whether these things have been argued in court. I mean, yeah, Martin, I think, is right.
You can't argue in court because you don't know. You see, that's the problem.
Well, I mean, you know, he seems to be arguing for a general disclosure of all our private lives there, then. But, you know, in the past, yes, the Neuberger report says that some of these orders were granted too readily, but not now, I think. Sometimes, the way we discuss these issues, you would think John Terry still had an injunction. You would think Max Mosley got an injunction.
So, Carl, where does this leave the right to privacy right now?
Well, I think it's in tatters if the media want to back Twitter users in saying it's a free-for-all. And if we have MPs, individual MPs like John Hemming, setting themselves up as the judge of the balance between freedom of expression and privacy, if we have that situation, then privacy is blown out of the water completely.
Last quick comment from Martin.
Along with the rule of law, some might argue.
Well, I agree with that point, actually. I do agree with that. I think what we need to have, I think that John Hemming yesterday made some completely nonsensical points about people facing secret prosecution and going to jail. There's no evidence of that whatsoever. Nothing of that sort is happening. That was rubbish. He and parliamentarians need to address the problem which, to an extent, they have created through the Human Rights Act. They need to tightly define it. We, as the media, we would like to see clear framework which would allow wider reporting of some of these cases, not a complete free-for-all, because we do recognise, I think, that some cases there are reasons not to report them. As we've said, blackmail and certain other cases may not be justified in any sort of public interest and may be harmful to report.
Gentlemen, we're going to have to leave it there. A fascinating discussion. Thank you very much indeed to all of my guests, Martin Bentham, Stephen Murdoch and Carl Gardner. And speaking of new media, do use it to get in touch. We're at Inside Story at aljazeera.net. We're also on Twitter and Facebook. We'll see you next time. Bye-bye for now.